Dear Prime Minister, I am Loo Ming Min, your appointed legal advisor. Today, I will present and explain the International Covenant on Civil and Political Rights, ICCPR, and also on the issue of reservation. In considering to be a party to the ICCPR, correct interpretation and understanding of the covenant is utmost crucial. ICCPR is an international human rights treaty which was adopted in 1966 and was ratified by the UK in 1976. By ratifying ICCPR, the UK agrees to ensure the enjoyment of civil and political rights, including the rights to freedom of thought, religion, and expression, and so on. Parties to the covenant may also become party to either or both of its two optional protocols. And today, we will be focusing on the first optional protocol, which came into force on 23rd of March 1976. It sets out a system by which the Human Rights Committee can receive and consider complaints from individuals who allege their human rights have been violated. However, it can only be used when all domestic channels have been exhausted. As its name makes clear, the protocol is not compulsory, but once a state party to the covenant also becomes a party to the protocol, any person subject to the jurisdiction of the state party may lodge a written complaint with the Human Rights Committee, subject to any permissible reservation. So, what are the impacts of the first optional protocol? The first optional protocol significantly enhances the ability of individuals to seek justice for human rights violation. It provides a mechanism for redress at the international level when domestic legal systems fail to protect their rights, thereby reinforcing the principle that human rights are universal and inalienable. Also, by enabling the HRC to review complaints, the first protocol promotes greater accountability of state parties to the ICCPR. It creates an additional layer of scrutiny, encouraging states to comply with their international human rights obligations. Next, the decisions and recommendations issued by the HRC contribute to the development of international human rights law. These decisions help clarify the provisions of the ICCPR and set precedents that influence national and international legal standards. Also, the first protocol places states under greater scrutiny, pressuring them to adhere to their human rights obligations. This scrutiny can lead to improved human rights practices domestically, and states seek to avoid international censure. Unlike traditional international treaties which mainly regulate the relations between states, human rights treaties, as a matter of fact, regulate the relations between the states parties, and in terms used in Article 2, subsection 1 of the ICCPR, all individuals within its territory and subject to its jurisdiction. This special character of international human rights treaties has great impact upon many aspects of human rights treaties, firstly reflected in the implementation and application of human rights treaties. The effectiveness of human rights treaties depends largely on their implementation within each state party. States must ensure that their domestic laws include substantive and procedural rules that give effect to the rights guaranteed by the treaty. Since human rights treaties focus on protecting individuals within a state's own jurisdiction, the mechanisms based on reciprocity are of limited relevance. For example, if a state violates Article 7 of the ICCPR by torturing its own nationals, it cannot justify other states torturing their nationals on a reciprocal basis. A member of the cabinet suggested that if Mandela becomes a party to the first optional protocol to the ICCPR, they should enter a reservation to Article 1. Coming to the question of what is reservation, according to Article 2, Paragraph 1D of Vienna Convention on the Law of Treaties, VCLT, reservation means a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application of that state. In some cases, reservation is referred to as understanding, explanation, or observation. It does not matter how the statement is phrased or what name is given to it. One must look at the substance. The International Law Commission was established to undertake the mandate of the General Assembly. In 2011, ILC came up with a guide to practice on reservations to treaties. It is a unilateral statement, however phrased or named, made by a state or an international organization, whereby that state or that organization purports to specify or clarify the meaning or scope of treaty or certain of its provision. According to Guideline 2.3 GPRT, a state of an international organization may not formulate a reservation to a treaty after expressing its consent to be bound by the treaty unless the treaty otherwise provides or none of the other contracting organizations opposes the late formulation of the reservation. In fact, the reservation is utmost important as this encourages more parties to a multilateral treaty, encourages harmony among states by concentrating on what is agreed and accepting disagreement. Yet, it is important to the principle of state sovereignty. So, how to formulate a reservation? Article 19 stated that a state may, when signing, ratifying, accepting, approving, or acceding to a treaty, formulate a reservation unless the reservation is prohibited by the treaty. The treaty provides that only specified reservations, which do not include the reservation in question, may be made or when the reservation is incompatible with the object and purpose of the treaty. For example, the International Court of Justice (ICJ) addressed the issue of reservation to the Genocide Convention case. ICJ held that a state that has made and maintained a reservation to a convention which has been objected to by one or more parties to the convention but not by others can still be regarded as a party to the convention. This is conditional upon the reservation being compatible with the object and purpose of the convention. The ICJ's decision emphasizes that even if some states object to the reservation, the primary consideration is whether the reservation is compatible with the treaty's object and purpose. This ensures that the treaty's fundamental goals are preserved while allowing for states to tailor their obligations. Apart from that, a reservation expressly authorized by a treaty does not require any subsequent acceptance by the other contracting states unless the treaty so provides, according to Article 20. Also, Article 20, Paragraph 5 stated that a reservation is considered to have been accepted by a state if it has raised no objection to the reservation by the end of a period of 12 months after it was notified of the reservation or by the date on which it expressed its consent to be bound by the treaty, whichever is later. While talking about objection, an objection is a unilateral statement by a state or international organization opposing a reservation made by another state or organization, aiming to prevent the reservation from having its intended effects, according to Guideline 2.6.1 of GPRT. Objections can be made regardless of the reservation's validity, reflecting the subjective judgment of the objecting party. Eligible entities include any contracting state or organization and any state or organization entitled to become a party to the treaty with legal effects contingent on consent to be bound. Objections uphold treaty integrity, ensuring reservations do not undermine its purpose and facilitating dialogue and negotiation among parties. Apart from that, Article 21 stated the legal effects of reservations and objections. When a state objects to a reservation but does not oppose the treaty's entry into force, the provisions covered by the reservation do not apply between the objecting and reserving state to the extent of reservation. Article 19 further stipulates that reservation incompatible with the treaty's object and purpose are not permissible. Proceeding to the compatibility with the object and purpose, Guidelines 3.1.5 and 3.1.6 of the Guide to Practice on Reservations to Treaty (GPRT) clarify the principle of compatibility concerning treaty reservations. According to Guideline 3.1.5, a reservation is deemed incompatible if it affects an essential element of the treaty necessary for its general tenure, thereby impairing its raison d'etre. This ensures that the core objectives and purposes of the treaty are upheld and not undermined by a reservation. Guideline 3.1.6 emphasizes that the object and purpose of the treaty should be determined in good faith, considering the treaty's terms, context, title, and preamble. Additionally, preparatory work, the circumstances of the treaty's conclusion and subsequent practice of the parties can also inform this determination. Furthermore, Guideline 2.6.6 states that a state or international organization may oppose the entry into force of the treaty with the reserving state if it formulates an objection to the reservation. This framework ensures that reservations do not dilute the fundamental principle of a treaty, maintaining its integrity and effectiveness. Whether Mandela can enter a reservation to the state Article 1 as suggested. Back to the first optional protocol of ICCPR. Article 1 stated that a state party to the covenant that becomes a party to the present protocol recognizes the competence of the committee to receive and consider communications from individuals subject to its jurisdiction who claim to be victims of a violation by that state party of any of the rights set forth the covenant. No communication shall be received by the committee if it concerns a state party to the covenant which is not a party to the present protocol. Under Article 19C of the VCLT, a reservation is not permissible if it is incompatible with the object and purpose of the treaty. The Human Rights Committee, HRC, in General Comment Number 24, emphasized that the non-reciprocal nature of human rights treaties, such as the ICCPR, means that traditional rules on reservation, which are based on reciprocity, may not be appropriate. The HRC asserts its competence to determine the compatibility of reservation with the object and purpose of ICCPR and to sever impermissible reservations, maintaining the treaty's effectiveness. Hence, the possibility of entering a reservation to Article 1 is contentious because it directly relates to the core mechanism of optional protocol, which is the recognition of HRC's competence to receive and consider individual communications. Entering a reservation to this article would fundamentally alter the nature of the state's commitment under the protocol. As in the Genocide Convention case, the ICJ held that if a party to the Genocide Convention objects to a reservation it deems incompatible with the Convention's object and purpose, it can consider the reserving state not a party to the Convention. This ruling underscores the importance of maintaining the integrity and core objectives of international treaties, ensuring reservations do not undermine their fundamental purpose. In conclusion, entering a reservation to Article 1 of the first optional protocol to the ICCPR, which would negate the HRC's competence to receive and consider individual communications, is generally impermissible. Such a reservation would conflict with the object and purpose of the protocol, which aims to provide an effective supervisory mechanism for the protection of human rights as set out in ICCPR. This conclusion aligns with both the HRC jurisprudence and the ILC's guidelines, reinforcing the principle that reservation should not undermine the essential elements of human rights treaties. Thank you.